included in it. And then it became an issue as to whether those delays that were not in the list of delaying events were not entitled to EOT. What happened with those? And so the common law concepts of time at large came about. Wherever a delay event is being caused by the employer or his consultants, it is deemed an act of prevention. And if those delay events are not within the EOT provisions, which means under the contract you're not entitled to extension of time, they will not excuse the owner completely, the employer completely. It will result in something called time at large, because the contractor cannot be blamed for a delay where he has been prevented by the employer or the consultants for the employer. So that's why these days you have a lot of standard form contracts being drafted with a catch-all EOT provision that says for any acts of prevention, there will be an entitlement to EOT. The reason being, if it doesn't get caught within the clauses in the contract, which allows an opportunity for EOT to be granted, if there is no such provision to cover a particular delay event, the concept of time at large will cause the employer to lose his right to liquidated damages, and the time will become at large. And who decides what time it is and what extensions of time? Well, the SO or the architect or whoever is in charge of EOT assessments can no longer decide. And short of the parties agreeing separately to an agreed extension of time, the other party that can determine the time is only the adjudicator or the arbitrator in those situations. So the danger of time at large has created contracts with the catch-all EOT provisions, but you still have other situations where time at large can occur, not necessarily only where the contract doesn't cover a particular delaying event. You have this other example of another bullet point in my long list of bullet points, which is where the EOT assessment is delayed. So when an EOT application is made and the architect or the SO, whoever's determining the EOT, takes an unreasonable time to decide, i.e., what is reasonable time has always been an argument, but unreasonable. But I think when we know what is unreasonable, if it goes beyond 1 year, it's pretty much arguable that it's unreasonable. You have contracts now that provide a fixed time for the architect or the SO to decide on EOT, such as the PAM form. And if that time has passed and no EOT assessment has been made, then those will all trigger time at large situations, which means the LAD falls, and the only other parties that can decide on time, it's no longer the architect, no longer the SO. It's either parties agreeing to it or an adjudicator and arbitrator decides the reasonable time. So those are the issues with delaying events covered under the extension of time clause and the legal and contractual issues arising from it. The other one that's created a lot of issues and a lot of litigation is the condition precedent notice requirements. And I know most contractors hate these clauses because it's a clause that demands certain notices to be given within certain times, failing which there is no entitlement to extension of time. And these clauses in previous history used to be read a little softer, a little less aggressive against a contractor because of the repercussions of there being no extensions of time, which is exposure to LAD. The laws seem to be a bit more relaxed and flexible on these condition precedent notice requirements, but it has changed over time. And the law now has become pretty much strict about any condition precedent clauses. It will be read strictly and it will apply strictly. And therefore, a contractor that has failed to issue the notices within the timeframes set out in the contract runs the risk that he will not be entitled to time, extension of time, even if the employer is the cause of the delay. That's how problematic it is and how strictly it's read. Now, not many people have put their minds to escaping a condition precedent clause. I've had the unfortunate situation of trying to do for some of my clients, and the law doesn't say condition precedent notice requirement is written in stone. If you don't follow it, you have no excuse whatsoever to get out of it. No, the law is quite practical. If you are able to show that whatever period that you were required to give a notice became impractical or became impossible, then you can escape the condition precedent clause. Now, what is impractical or what is impossible? You have to be creative about that thinking if you're on the side of the contractor. But there are situations where I'm sure it can be argued and an adjudicator and arbitrator can be convinced of that. Now, there are contracts, and this is where the interplay comes between the notice requirements in different contracts. Some contracts require you to give a notice of a delay affecting the progress. Some contracts require you to give a notice of a delay affecting the completion date. And they're two very different things, because delay affecting the progress, a contractor ought to know the first very day of delay, his progress is not moving ahead. He should know the first very day. By the evening, he should know, he should be able to issue the notice. But as to whether it affects a completion date, that's a little bit trickier, because that requires the contractor to work out, number one, the delay that is occurring, the activity that's being delayed, is that on the critical part? And how will that critical part eventually impact the completion date? So there's an assessment and an analysis that has to be done. And when you throw in an obligation to mitigate, which most contracts have, that's when the contractor, a clever contractor, can say, I was delayed in issuing the notice because I was trying to mitigate. And when I'm trying to mitigate, I don't know whether this delay is going to affect the completion date until my mitigation failed. Then only do I realize I have a notice to be issued. So there has been those situations that arise that have become a valid excuse. Now, the position in condition precedent notice requirements have got so strict that even for well-known delays that everybody at the project site knows about, the impact that everyone knows about, a notice is still required. Now, the previous law used to give a way out. It used to say that for delays where the SO had total knowledge, then there was no need for such a notice. However, now the readings are going very strictly in favor of the condition precedent. So this excuse is no longer available. So it can lead to an extremely nonsensical situation at times, where, take for an example, site possession is not being given at all over a period of 2 weeks. Everybody knows there's no site possession. Everybody knows the impact is 2 weeks. Yet if you don't give your notice, you don't get your EOT. That's how difficult it can get. Now, waiver, that's another argument that all lawyers used to love raising, waiver of the notice requirement, because the architects and SOs at times invite an EOT application, and then the contractor can argue, by inviting me to apply for EOT, you're waiving any failure that I made in giving you an earlier notice. The law on that too has changed, and it's become clear that the waivers must come from the contracting party and not from an SO or an architect in the PAMS situation. So it must be only from the contracting party, and waivers from architects are not longer applicable. Obligation on mitigation, as I mentioned, it's not a very strict requirement. There is an obligation, but how strict must a mitigation be implemented when you are not at fault? As a contractor, if you're not at fault, do you need to spend money to try and somehow or another mitigate? The answer is no. It must be within reasonable circumstances. The other one that the contract tends to always affect assessments of EOT is prospective or retrospective delay events. And in that respect, one has to look at when an application has to be made. The completion date is still far away, and therefore it's a prospective assessment of the future impact on the completion date. But the application for EOT is always made after the delay event is over. Hence, it's a prospective impact on completion date, but retrospective the delay event period. And then an assessment of EOT is made. As I mentioned earlier, delayed assessments of EOT can lead to time at large arguments. Post-CPC reassessment of EOTs. Now, that's very interesting because the PAM contract has got a provision that allows the architect post-CPC to reassess the EOTs, but it's not a compulsory clause. But when he reassesses an EOT at that stage, the test is total retrospective assessment, because he's looking at it after CPC to realize how much of an impact it had. That clause was drafted to really allow an SO and architect to avoid the condition precedent arguments by reassessing it after the CPC. But it's not compulsory, and that's what contractors need to know. CPN requirement, that is critical path network requirement for assessment. Now, normally it is expected to apply. It is the benchmark of testing and analysis of an impact, cause to effect impact, and whether that impact is critical enough to delay the completion date. So unless the contract excludes the use of CPN, I would think the law today has recognized CPN to be the correct way of assessing EOT. Is the method of analysis dictated by contract? We have seen contracts where some contracts do give you the method, or do prescribe the method, or prescribe some standards which fall into certain methods. And the last one I would like to talk about is post-original completion date variations. Now, the PAM contract has a clause, and there's been a lot of ambiguity about the particular clause as to whether it's an automatic right to EOT, regardless of the criticalness of that variation, or whether it still should apply critical path. And that's left to the courts to decide. It has not been totally analyzed. I believe it's in the way, in present moment, a lot of arbitrations are facing this issue with this PAM form. And this will obviously be dealt with in future by our courts. Okay, thank you. That's about contractual entitlements and limitations.
Thanks, Belden. Now moving on to culpability and evidential causation of delay events. Establishing causation is obviously the key to the success of the claim. And that is the cause-effect linkage between an event, such as the introduction of an instruction to do more work, and the resultant delay to completion of that impact. That's the challenge before the party making the claim, which is a contractor. Anything less than establishing this causal link will fall short of the requirement to demonstrate the entitlement to EOT. So, as Belden has just mentioned, impact analysis, delay analysis is the standard which is required now. It wasn't before. It was very much a subjective, impressionistic view of the SO or the architect or the engineer. But now delay analysis has its important part in demonstrating the impact of the events. In terms of culpability, responsibility for the excusable delay, once it's established that under the contract, the employer has taken responsibility for a delay event, that would be either with time and money, or if it's a neutral event where the employer takes responsibility for the time impact of the neutral event, that would be a time impact only without, under the contract, a right to recover additional cost. So there is a distinction there, depending on what the contract says. The net chain of causation from delay event to delay impact is what needs to be established all the way through from the event occurring to its impact on the overall completion. And establishing the delay event would either be prospective, or whether after the event it's been demonstrated that the delay to progress of a particular activity of work did as a matter of fact take place, would be a retrospective analysis. Now the contracts, the construction contracts anyway, usually anticipate a prospective analysis. So where the contractor is required to provide a notice of an event which has taken place or is taking place, it's at that time when the event occurs that the contractor is required to give notice and to claim the delay to completion. And at that time, during the course of the work, the contract administrator is required to decide whether or not additional time should be granted. That's during the event on an interim basis, or soon after the event has ceased, to make a decision so that the contractor knows how much time at that time he's entitled to carry out the work and complete it. But very often, the claims are put in much later, and with then the benefit of hindsight, knowing what's happened, the assessor can make a retrospective analysis and assessment after the event. And very often, final claims are made at the end of the project when the effect of those events are known. So that's the difference between prospective and retrospective analysis. Belden's mentioned mitigation, the obligation, either express or implied, to reduce the impact of the delay. that would be an obligation on the contractor, which wouldn't come with obligation to spend any or much money, but to reprogram and make more efficient the work which is remaining in order to reduce the impact of the delay. And therefore, again, could you please put your microphone on silent if you haven't already done? Put it on mute, please. Thank you. I seem to be the one getting the interruptions today, not you, Belden. Okay. In terms of mitigation, that would be an ongoing obligation along the way. So as an event occurs of potential delay, the contractor must at that time decide and assess whether there's anything he can do to overcome the impact of that delay. And last bullet, the analysis, criticality of delay event impacting the completion date and period of EOT. That phrase, criticality of delay event impacting completion date and period of EOT, is really the goal, which is demonstrated through reference to documents, narrative of a claim, and that all-important delay analysis to demonstrate the causation from the event or events through to the actual impact to the completion overall. So going on to the next slide, sorry. Going into a bit more detail on the analysis of the critical impact and period of EOT, it very much now revolves around delay analysis. The challenge here are the availability of the data for accurate analysis. Of course, the contract may say the contractor must update his program regularly, keep sufficient records and so on. But from experience, it's clear that most projects have inadequate records. It's very rare to find a project which has adequate records to demonstrate the delays which occur from time to time, notwithstanding the requirements under the contract to keep good records. And therefore, the challenge is the strength of the analysis that can be produced to demonstrate the claim. So if we have perfect records, then we can have perfect analysis, and the opposite is true. And that very much dictates the type of analysis which is undertaken. Evidential causation of the critical impact of the completion date, undertaking an analysis of the evidence as a matter of fact. We have to look at actually what happened, not theory of what was meant to happen and what could have happened, but actually what did happen in the event. And the analysis takes into account those facts. So if we have the records of what happened, then it's easier to undertake the analysis. At the beginning of every project, there's usually a requirement to produce a baseline program, which is approved by the SO or the engineer or the architect. And that approval is to give a nod to the contractor to say that's a practical plan of how the work is to be carried out. But that, having established the reasonable period for activities in order to carry out the work, is no more than a plan, and once it's approved, is meant to be followed until events occur, either for which the contractor is responsible or for which the employer is responsible, and the program may have to be updated and revised from time to time. There are two parts. One is an original program which is changed because of change events. Another is an original program which has progress recorded against it. So we have perhaps divergences from the original plan, which are recorded from time to time. They may be approved, they may not be approved. There may be a dispute about that resequencing. And then we have the recording of progress on the program itself, which is equally important for the analysis to be carried out. Now, there are often disputes and disagreements, and a reluctance, perhaps, on the administrator's point of view, from his point of view, to approve a program which perhaps shows a completion date later than the already extended or original completion date under the contract, because that would suggest the contractor is going to breach contract by not complying with the contract. Now, there may be a situation where more extension of time is due and not granted, and we have disputes arising along the way before perhaps formal disputes during the course of the contract. So these are practicalities which then go back to the availability of data for carrying out the analysis once an EOT claim has to be produced. So if the parties are reasonable and proactive and produce the records to take into account the circumstances which will change along the way, then there will be a good body of data and record to use, which, if they're contemporaneously agreed, will be useful in arriving at an agreement on the extension of time claim. If that process hasn't taken place and there's no agreement, then it's less certain as to whether or not the EOT will be on a firm, contemporaneously agreed basis. So these are practical considerations for collecting data and then using data in the preparation of claims. Of course, the program itself may not be perfect. The logic inside the critical path network program as a function of a computer program needs to be correct in order for the impacts of events and their true impacts, the logic sequence of events shown in the program has to be correct in order for that demonstration to be shown correctly. And there can be retrospective analysis of the logic of the program, and it can be only when there's a problem and there's a delay that has to be impacted and demonstrated that these issues with the logic links of the program come up. Those have to be dealt with, and agreement has to be reached on the implications and the necessity for such corrections to be made. Float-in program is available spare time, to put it in layman terms, which could impact the delays. And if there is float available spare time, that would need to be taken into account in any assessment of extension of time, because that could, of course, reduce the impact. If there is spare time available, contingency time available, that would need to be taken up and taken into account before giving a net EOT or any EOT at all. And float, like a program and the sequence of activities, and like the critical path in a program, and the critical path is the shortest distance between the beginning and the end of the program, sequence of activities giving the shortest possible time for the completion of the project. And therefore delays really are by reference to the activities on the critical path. Any float which may be in the program will appear at different times. The critical path may change at different times. So a prospective analysis at the time of the event occur is very important to identify where the critical path is at that time and where any float is, if at all, compared to an analysis of a baseline program, which is a static representation of the intention, which doesn't give the same causation analysis in the delay analysis to demonstrate the impact of the delays. So these are all important considerations when preparing an extension of time claim, which must be provided with transparency and clarity by the claimant in order to demonstrate the entitlement to the contract administrator, or indeed the adjudicator eventually, or the arbitrator. Other points to make out of these bullets would be, of course, the analysis depends heavily on the facts throughout. Impressionistic, theoretical analyses, global analyses are really not acceptable. They may have been in the past, but now the use of programs and proper analysis is, as Belden mentioned earlier, the standard required, and there's no getting away from it. Without good records, then it will be very difficult to demonstrate on the fair basis that we now take for granted the entitlements which are being claimed. There are different methodologies which we really don't have time to go into in this session, but snapshot window slicing methods, which take a great amount of detail and data and analyze the program in short periods of time, looking at what the situation was on the program and the project at that time from month to month, and the impact of events within those programs, and then building up an overall picture of the assessment and the impact of delay events is much more preferable because of its detail and its accuracy than other types of methods of analysis, such as observational or theoretical methods, where there aren't adequate records, and it's really up to the claimant to make use of the very limited data that they have got to try and make a play for a claim. But of course, with better records, better analysis can be carried out, and the standards required to establish the entitlements because of delay can be demonstrated. Okay, I think because of the time available, I'll move back to the second section, which Belden will deal with, because it's largely dealing with the law, and that's the trinity of common law issues, common issues on LADs. So we're looking at contractual entitlement and administrative requirements of LAD, interplay between EOT and LAD, and the evolving law on LAD in Malaysia, of course, and confusions thereof. Belden.
Okay, thank you. I'll need to really be very rapid fire on this now. LAD is a creature of contract, so there's no LAD clause. Actual loss is the claim. Most contracts have a requirement, a prerequisite, which is called a certificate of non-completion. But if the contract doesn't have one, then that's not required. Some contracts have a notice requirement even for the employer, and it's a prerequisite, and employers must beware that they too can get punished for failure to issue a notice. And you have even some contracts with very unique procedural requirements, FIDIC clause 2.5 and 3.5. I'm talking the yellow book here. They require not only a notification, but a whole process of parties trying to spend some time trying to agree on even the LAD before the LAD can be imposed. And if these procedures are not followed, the LAD is lost. The question of whether only prospective LADs from a CNC or a notice, or whether retrospective is possible, is about the contract clauses. I've seen contract clauses that say LAD can be imposed from the date of the CNC or the date of the notice, which means if you issue a CNC late, if you issue a notice late, you've lost the earlier period of LAD. But not all contracts have those kind of wordings. So if they don't, then the LAD runs back to the time when the delay occurred. Entitlement to LAD up to termination of CPC or CPC. This was a hot point previously under a Court of Appeal decision called Triple Point, but that Court of Appeal decision has moved up to the Supreme Court, and the Supreme Court has made a decision that it's very clear LAD clauses run up to termination. They cannot run up to CPC once there is a termination, but obviously if there's no termination, they run up to CPC. And the fact that the termination has occurred doesn't mean you've lost the right to LAD. Delayed imposition of LAD and the effect. Well, a lot of employers delay the imposition of LAD to encourage the contractor to continue the project because they feel that if they cut off the cash flow, the contractor will walk away. So what is the effect? The delay to the imposition of LAD, as long as it didn't become a waiver, it was reserved. There were letters written saying the right is reserved, then the law will not read a delay in imposition of LAD as a waiver. As I mentioned earlier, time at large can impact an LAD. What happens with inapplicable or inoperable LAD provisions? You still have, then you have to prove actual loss, but your cap on actual loss will always be the LAD, and you cannot go beyond that. And then the question of COVID Act, which recently became an issue. COVID Act unusually doesn't deal with the right to EOT. It actually deals with the right of the employer to penalize a contractor, which is LAD. And so the COVID Act has to be read in line with COVID impacts on LAD and its effect on LAD clause, LAD rights and provisions. Now, the next slide, please, Rodney. Interplay between EOT and LAD. So the interplay is obviously if there's an EOT, there's no LAD, but then the administrative requirements are the question mark. Now, what happens when EOT is not granted, but an arbitrator later grants an EOT? Does that mean the whole LAD is destroyed? The answer has been very uncertain by a lot of cases, whereas in some instances, the viewpoints suggest that the LAD is completely lost. And in some instances, the viewpoint suggests that it just reduces the period of the LAD. For me, the answer lies in whether the assessment of the LAD was merely an erroneous assessment, which means an error by the SO or the architect, or was it an unfair and unreasonable assessment? Because if the assessment was unfair and unreasonable, and then it's not just erroneous, the chances are then the whole LAD is gone. Now, is LAD a disproportionate application when an employer causes a delay, but you don't get an EOT because you did not give a notice? Well, the question of disproportionality comes into play in my next slide, which I will explain. It's a question of when the contract was entered into and not when the LAD is being imposed. So the chances of this helping out a contractor is not going to be there. But in terms of the CNC, that is an interesting thing because the CNC in the contract normally, sorry, can you put off the sound? The CNC in the contract normally requires a exercise of an opinion by an SO as to when the work ought to have been completed. Now, if the SO knows of a culpable delay event caused by an employer, and has not granted an EOT simply because of a notice requirement, how does he exercise his opinion? Is his opinion fair and unreasonable? That's a very interesting indirect way of getting around certain notice requirements if the SO can be proven to have full knowledge of the delay and the impact of the delay, then is his opinion a fair opinion in the CNC? Can I have the next slide, please, Rodney? And then the last one on this is the whole area of law and cubic electronics. And this one has created some level of confusion to some lawyers, not all. Cubic electronics, does it reverse Selva Kumar? Some people think it does. Some people say it didn't say so. So on proof of actual loss, is it really out? Now we know cubic electronics reintroduced the applicability of the Cavendish principle, which is that it must be reasonable compensation using proportionality linked to a legitimate interest. It completely doesn't, penalty doesn't apply here. The burden was very clear. It was stated clearly that the burden is on the contractor to challenge and establish the LAD as an unreasonable compensation. But what got a little bit surprising in the federal court decision is when the federal court also referred to actual damages being a means of proving reasonableness and proportionality. So therefore, everybody thought, oh, so the actual loss is not completely gone. It's still there. The federal court mentions it as that is the good starting point to prove reasonableness. Well, it's a starting point to prove reasonableness when the contractor or the party attacking the LAD is able to establish, is raising the fact that it's unreasonable, is attempting to prove it's unreasonable. If you come back in defense and prove that your actual loss kind of matches your LAD, then you're proving it's reasonable. But it's not the the test that you need to establish actual loss for every LAD claim. It's a mechanism, using actual loss as a mechanism to avoid the argument of unreasonability rather than having to establish it for every claim on LAD. What is important with the Cavendish test is to understand that the Cavendish test applies the question of reasonableness and proportionality to when the contract was entered into, not at the time when the LAD is being claimed. That's why the Cavendish test uses the word level of loss or damage likely to be suffered. At the time of entering the contract, you don't have a loss, but these are the losses likely to be suffered. So the test becomes very, very different in my view. And what is legitimate interest when it's linked to proportionality? That means you can bring in, apart from pecuniary losses, money losses, you can bring in other types of losses that can allow the LAD to be thought of as reasonable. Thank you. This is on LAD. We'll move to the next one, which is the trinity of common issues of loss and expense and prolongation claim. Again, I will go very rapid on this because I'm doing the first one, contractual entitlements and limitation. Again, analysis on compensable delay and standard of proof of quantum. The other two, Rod will do. Can we go first to contractual entitlements and limitations? This is loss and expense or prolongation claim. Is the delay event compensable under the contract? That's your first stop. Because if the contract doesn't allow you to make a particular claim, so be careful. Not all delay events giving you a right to EOT automatically give you a right to loss and expense under the contract. It's a far more limited number of delaying events that gives you a right to L&E, loss and expense. And very often, the contract will exclude any other right to loss and expense. So if it excludes any other rights to loss and expense, then you don't have a right, and it's a contractual exclusion clause or limitation clause, which can only be avoided by very few means. But a lot of people get confused with this right to common law claim and right to contractual claim. And is prolongation claims, can it fall under common law? The answer is it can if the contract clause doesn't exclude the common law right, but at the same time, it limits your common law rights to those that are already covered under the contract or already excluded under the contract. You are stuck with the contract. You cannot go to common law to save you when your contract has given a right or removed a right. It's only there when certain things happen, like time at large happens, and there's a possibility when time at large happens and reasonable time being assessed by independent arbitrator adjudicator, then does your loss and expense clause apply any longer? Those are ways around the loss and expense clause itself to to create it as being inapplicable or inoperable, and then you go back to common law, which means you've wiped out the clause. But if the clause still applies, your common law is diminished by whatever is in the contract. So is EOT a prerequisite to a claim? The answer in most contracts, it is not prerequisite to a claim or to a notice. It is prerequisite to getting the money, but it's not prerequisite to making a claim, because that's why the condition precedent on loss and expense clauses exist. They encourage you to make a claim, even though you may not have got an EOT, as a way of setting out an entitlement. And then whether you get it or not is to be dealt with later. Sometimes a lot of contractors think that's extremely unfair. If I haven't got an EOT, how come I must make a loss and expense claim? Shouldn't I fight for this all over in an arbitration? The answer is, unfortunately, the contract clause says it's not subject to being given an EOT. You're required to try your luck and make the claim for the loss and expense. And if you don't, you're prevented from claiming it, then you're stuck with the condition precedent clause. Again, how do you escape a condition precedent clause? There's ways of arguing impracticality, impossibility. That's very factual sensitive. You can use the mitigation argument as well at times. Now, supporting your claim for LNE, you need causation, you need documents, obviously. LNE is not a creature of some kind of theoretical claim. It's an actual loss claim. And retrospective impacts and retrospective prolongation assessments of loss and expense is a very interesting thing, because I feel that there are standard forms these days that have made a critical error in the way they suggest loss and expense claims be dealt with. A lot of the standard forms in Malaysia suggest that the claim must be made early on, after the delay event is over. You make your claim and it gets assessed early on. Now, we all know in a prolongation situation, there are many loss and expense impacts that only occur after the prolongation. Let's take insurance renewal. Let's take bond renewal. There are many costs that you only incur at the end, after the completion date, when the prolongation happens. Yet you're supposed to make a claim when the delay event occurs much earlier. That is extremely problematic, and I feel a failure in the eyes of those drafting the contract to understand that loss and expense has got two elements: an impact period element and also a prolongation period element. Even recurring site expenses during the prolongation period, the cost can be inflated due to inflation. And why are you losing out on that additional cost by having to claim only the impact period? Those are question marks that one has to be concerned about in the way the contracts have been drafted. So likely to incur or has incurred, that also depends on the contract clause. Now I'll pass it to Rodney to talk about the other aspects.
I think on that point, that last point, Belden, it could be two heads of claim, one for the period in which the event has occurred, and then if there is a top-up because of inflation at the end, perhaps the contractor could give notice of that as well as a direct impact of the event. Yeah, but you're quite right. These are quite
unfortunately, the contracts don't seem to provide for that. They want claim also to be made early on.
That's right.
It's not just a notice, it's also a claim. Okay, anyway.
That's right. That's right. Okay, so now looking at the compensable delays, the SCL protocol is very useful in setting out that loss and expense actually suffered is what's recoverable. And the test is to put the contractor in the same financial position it would have been had the employer risk event not incurred. Not a penny more, not a penny less is the idea in accordance with the general principles of damages. So it's the actual cost suffered, as Belden's already mentioned. And if we look at things like the impact period for site overheads, on a site, there's a resource curve. At the beginning of the project, it starts low in cost. In the middle, when the height of activity is going on, it's higher. And towards the end of the project, it goes down to a lower level again. If the contractor is claiming the cost incurred in the prolonged contract period, he's shortchanging himself compared to if his delays occurred in the middle of the project, when all the plant equipment and resources of a management type are at their height when he's spending the most money. So this is why it's important that the delay periods in the delay analysis are identified first, and then the compensation, the loss and expense claimed, matches those periods. And of course, the converse is true. A delay at the beginning of the project where no money or very little money is being expended would result in a much lower loss and expense, but it would put the contractor back in the position he would have otherwise been in but for the delay. So we're talking about by reference to the period when the effect of the employer risk event was felt, not by reference to the extended period at the end of the contract. Unabsorbed head office overheads and formulae, we're not actually looking at actual cost when unabsorbed head office overheads and formulae are used for head office overheads. That is loss of an opportunity. So it's not an actual loss in terms of loss and expense. It's a lost opportunity to earn revenue because of a delay. And where contracts allow the contractor to incur, claim additional cost, then a loss of opportunity isn't a cost claim. Disruptive claims as part of the delay event. There's often confusion between a delay prolongation claim and a disruption claim. Delay can cause disruption, but the two things are quite different. There may be a connected claim for disruption, but that would have to be claimed and explained separately from a pure prolongation time-related claim. Another aspect is variation delays versus loss and expense claims. A variation may be instructed at the time of the project, which causes a delay, and in itself needs to be paid for as varied work if it's additional work. So there may be delay, loss and expense, and there may be provision in the contract which allows for the total impact of the variation, the physical work, and the impact on progress to be compensated and valued in one go, or these may have to be dealt with separately. But the usual rule is the contractor can only recover that additional cost, which he wouldn't have recovered under any other contract clause, i.e. variation valuation clause, and he can't claim and recover twice. So it's only claiming once, whether it's valued under the variation clause or under the loss and expense claim clause. Lack of own efficiency and productivity as a discounting factor. Has the contractor claimed only because of the event? Unless was he inefficient as a result of the delay, then perhaps he can claim. But if he had inefficiency and productivity issues of his own making, then obviously he would not be able to claim for that. And we're getting into the realms of global claims. So the contractor must be very precise where claiming for prolongation or disruption, which are not his responsibility and for which he can claim compared to his own inefficiencies. And in construction projects, it's very difficult for contractors and subcontractors to sometimes separate the two competing causes of loss. Concurrent delays are very important for loss and expense claims because the position is generally that where a contractor is responsible for the delay and another delay is occurring at the same time, there are concurrent delays of having the same impact, then the contractor is entitled to the extension of time for the owner, the employer delay event, to avoid liquidated damages for which he shouldn't pay because of the employer event. But at the same time, he cannot recover loss and expense in that period because he would have incurred that cost in any event because of his own delay. So often a defense to a loss and expense claim is that the contractor was in concurrent delay. That has to be established as a matter of fact in order for that to be successful as a defense. Going to the next area, the standard of proof of quantum. Actual loss and expense, as I've mentioned, is what's required to be demonstrated. So contractors who merely pro rata the preliminary prices in the contract are not achieving that required standard because prices are not costs. Prices are a predetermined amount that the contractor has tendered upon for the price of preliminaries. It's not actually demonstrating costs. So actual records must be made available of actual additional cost in those delay periods. Primary source documentation that can be tested. Well, proof of payment may be complex. Contractors pay at different times for different invoices, etc. And there has to be a very detailed assessment and analysis of the documentation to demonstrate that the payment has been made. Then there's a difference between a liability to pay and whether payment has made as a matter of fact, and that becomes a legal test and a decision for the arbitrator or the adjudicator. Explanations and calculations to assist the assessment. Of course, the data which is generated going down to trivial items of stationery and grab drives, etc., all become items of cost which may be relevant, but demonstrating the cost incurred on a day, in a month, in a year becomes quite tedious. But once the actual overall cost has been documented and demonstrated, the number of days in a month may not be possible to be established precisely, and therefore average cost in a day per month will normally be acceptable, even though there's no difference between the first and last day in terms of assessment. So the use of average rates per day per month is acceptable, but average rates per day per year would be a too long period within which to make an average. So averages are acceptable to an extent, but at the end of the day, the contractor has to demonstrate his actual loss. Data protection legislation now provides further complication and problems for those wishing to demonstrate their claims because of the right for individual personnel to have their data protected. There are ways around this. The person who's going to be assessing the claim can be invited to the contractor's organization to review records in confidence, etc. Records can be summarized without disclosing individual records of staff and so on. So it is possible, and it's not an excuse to be used, that the data is not available because it's protected. The contractor still has to demonstrate its claim and overcome those hurdles of legislation to keep information private. So now, that was not so quick fire, but it was pretty quick based on what we got through. We've now got about 10 or 15 minutes to get through the key area of today, which is strategies dealing with these common issues in adjudication and arbitration. And we're going to deal with this. I'll let Belden just explain the areas we're going to look at.
Okay, sure. So we started off by asking ourselves, what are the real differences when you're dealing with time-related claims in adjudication and arbitration? And these seven bullet points is what we came up with. Time available. Obviously, we know the distinction between time and adjudication arbitration, and that tends to have a big impact on how you present or your strategies in relation to the claim. The level of preparedness that is expected for adjudication versus arbitration. We know rough justice means less preparation. Level of documented evidence available. Level of details to be presented. They're quite distinct in adjudication arbitration. Level of details that can be comprehended by a determiner. As an adjudication, you have 45 working days. The question is how you're going to make the decision without even hearing the experts out. There is a sense of biasness to contractors for adjudication, so that affects the strategy that tends to be taken by respondents in adjudication. And credibility is a far lesser effect in adjudication than in arbitrations because of the existence of cross-examination. These are the key ones. So I will start off with the role of as a representative for a party, whether it be claimant or respondent. What are the issues that tend to pop up as a strategy on adjudication? Now, for loss and expense claims in adjudication, you should be presenting it. Normally, I would expect to present it using an expert. Obviously, if it's a very simple claim, a very small claim, you can use your project QS to save cost. But you would normally, if it's a larger claim, you would expect to be able to use an expert to be able to flush out all those stuff that Rodney talked about in terms of the standard of proof and the analysis of the proof on what heads of claim you're entitled to, especially the impact period versus the prolongation period. However, on the other side of the coin, there are some authorities now that have suggested that loss and expense cannot be adjudicated. I believe there is a High Court decision that suggests that loss and expense doesn't qualify as a claim for work done. And there are other High Court decisions that have suggested it can. And this matter, I think, is on its way up to the appellate courts, and we'll see how it goes. But at the moment, I tend to accept the view of the decisions that have said that it can be claimed loss and expense because it is still a cost incurred for the work done. It's a time-based cost, but time is part of doing the work. So for me, you can't distinguish time and physical work because they both come into play when one is being a contractor. So when to raise the entitlement of the EOT, that's another interesting thing because EOT is generally used as a defense against an LAD that is also a defense against a claim. So a contractor starts with a claim, certified sum or uncertified sum. Then he moves on to the defense being LAD. Then does he come back with the answer EOT only in the adjudication reply? Obviously, if the contractor is also claiming loss and expense, he needs to flush out the EOT in the adjudication claim. But if he is not claiming loss and expense, he's merely claiming certified or uncertified sums, then does he wait for the adjudication response to raise the LAD and then come back in reply. But whenever I find that a representative has done that, raised an EOT argument in the reply and brought out an expert report in the reply, generally a rejoinder or a subjoinder is then allowed, and it just doesn't serve its purpose because it gets more complicated when time is shrinking. Now, use of expert for EOT disputes and approach to detailing, and the report, obviously, that's a big issue amongst lawyers as to when is the expert being brought in for EOT, how much time does the expert have, and I think some of these strategies are based upon whether there are other strong arguments. For example, if LAD is being used, are there other strong arguments against LAD? If you think there are other strong arguments against LAD, you may not worry too much about the quality of your EOT assessment and your EOT reporting from your expert. So those are the issues. Now, on the other hand, as a respondent, sometimes the trick with limited time is to attack the application for EOT rather than go behind the whole argument about what is truly an entitled time. If you attack the quality of the application for EOT, or it didn't come with documents, it's missing this, it didn't have an analysis, then the question mark comes as to whether that's enough as a respondent to avoid EOT, or whether you still need to prove that on an analysis basis, this EOT is not applicable. The question always turns as to the concern with how adjudicators treat the burden of proof. Very often, adjudicators, with that sense that they need to allow cash flow, tend to always put the burden on the respondent, which is not right in the law of dispute resolution. So this is where it always troubles the respondent as to whether you put all eggs in one basket and just attack the EOT application and not also deal with the EOT entitlement per se. Then the next question, key factors: early preparation, quality of the EOT application. So if my client's EOT application was very weak, I need a better expert in. My client's EOT application was strong, then my expert's time is lesser because he's got a quality product to work with. Those are the question marks you ask for adjudication because it is such a fast-paced thing. Now, understanding the burden of proof and required standard of proof, the question mark as counsel is that in adjudication, do you understand that or do you leave it to your expert? Please remember one thing, experts have a view of certain things that can turn out to be wrong in terms of standard of proof and burden of proof. So it takes two to tango, and I've always believed in that. I believe a lawyer shouldn't say, oh, this is an area for my expert, and I'll leave it to him. I know time in adjudication is very troublesome. It's very tight, so the tendency is to divide and rule. Let your expert deal with this, you deal with the contractual arguments. But at times, you need to have some background understanding so you can even have a quick look at the expert's report and determine whether that quality is acceptable to you or not. Approaches depend also sometimes on who and the background of the adjudicator. Obviously, if I've got Mr. Rodney Martin as the adjudicator, my approach to EOT application would be very different from having Mr. Belden, Premaraj, who may not totally understand programs, although with that experience I can, but the approaches turn on also looking at who the adjudicator is. Dealing with contractual limitation and adequacies of EOT application is one way around the bigger problem. Focus the fight there, because it's easier for the adjudicator to understand that than trying to understand actually what is the critical part and where the assessments went. New evidence not presented by the party during an application and assessment. This is a very interesting story because it actually applies to adjudication as it does to arbitration. Do the arbitrators or adjudicators think that they are making their mind up as to what EOT applicate, how much EOT is entitled, or are they deciding what EOT would have been given or should have been given when the application was made? Some people, some of the determiners think they are the ones now deciding it as if it's afresh, as if the project application, all that can be not considered. And I believe somewhere along the line, that's not totally right. But there is one aspect that plays into most minds of adjudicators and arbitrators is that you are making a decision very retrospectively. So can you ignore retrospective facts and just apply a total prospective analysis and assessment? It is difficult because it's a human nature to look at all what happened and say, hey, it didn't really cause that delay. So prospectively, you would have been entitled to it, but after the event, after it all occurred, by the time you got to CPC, I can't see that this caused the delay. Requesting early for oral presentation by experts. Now, again, on the strength of your case, if you're very dependent on an expert, early request for expert to be heard by the adjudicator is something I always prescribe, because it's given the chance for the adjudicator to understand it better. Now, early is the test, because if you ask too late, the adjudicator is entitled to say no. He's got 45 working days. He can't spend the time. And the courts have said, you ask late, it is not breach of natural justice. You ask early, and the adjudicator who's not an expert in the area refuses to hear the expert, it can be a breach of natural justice. Next slide. In arbitration, it's a different ball game. You now have time. So as a counsel in arbitration, thoroughness and detailed consideration of time claims are expected. It can be done. You've got all the time in the world. It has to be done. Use your experts well. Get them in early. Use experts. All arbitrators expect experts to be involved, especially since there is enough time. Understand one thing, though. In arbitration, credibility, independence, and factual testing will occur through this process of cross-examination. And now what generally happens is hot tubbing, where two experts get to face each other and discuss a particular topic, and then questions are asked. So because of all of this, one has to be careful about how thorough and how detailed the assessments are. You'd expect your expert to be thorough and detailed, but expectation alone doesn't help you. If you're the leader of the case as a counsel, you got to know, which means you've got to understand, which means you've got to understand some amount of ability to understand time-related claims, EOT analysis, critical part analysis, being able to understand that sufficiently. One, to test your own expert to see whether your expert's preliminary reports are up to the standard you want your case presented, and also to be able to cross-examine the other expert, because it has to be done fluidly with your own understanding. Cannot turn around and always depend for your own expert to give you every question to ask. That just doesn't work very well. And you must appreciate that good arbitrators are very capable, and they have the time to understand and appreciate the evidence. So thoroughness and detailing is totally required. The next one I move on is the next slide, please.
That's me, Belden.
Yes.
Looking at the strategies as expert in adjudication and arbitration. So just briefly, because Belden has dealt with some of the points already, I'd just like to say initially, the expert's duty in adjudication is no different than his duty in arbitration, and that is to assist the adjudicator in adjudication and not to be partisan to his parties. Now, there is a temptation, as Belden has alluded to, because there's unlikely to be oral challenges, because there's unlikely to be testimony, that the expert who's more leaning towards a hired gun may be tempted to be more bold because he's not going to be actually tested on his report. On the other hand, because there's not much time, it's imperative that the expert ensures that his report is as clear as possible and easily to understand with simplicity and clarity, because the adjudicator just does not have time. The other point is, of course, there's unlikely to be much time, if at all, for rebuttal, and certainly not a joint statement. So the process in adjudication is different than obviously in arbitration. So the report that goes in from the expert has to be absolutely complete, everything considered, and not holding back, expecting to respond to the other side. Of course, there is a reply in adjudication, but it's only 5 days. So in anticipation, expecting what to write in a rebuttal report in the reply is a dangerous game because of the timescales. So it all comes down to the way in which the report is presented, of course, honestly, independently, but the way in which it's presented simplistically, using slides if there is a presentation, and even using slides as part of the report to summarize and present to the adjudicator the evidence that the expert is producing is very important. So will the best presentation win? It may well do, because it may be easier for the arbitrator to understand, the adjudicator to understand what's being put before him. And it also depends on the experience of the adjudicator. Would it be wise to encourage oral presentations? It may, or it may backfire. And that's also for the case for the adjudicator himself or herself. So it may be useful to have oral presentations, or it may not. Depends on the circumstances. Next is strategies as expert in arbitration. As Belden said, it's a different process. It's much more detailed. There's much more time, all the time in the world, almost. So a much more thorough presentation, research. There will be more time. The other thing about adjudication, just going back there, is it's not realistic for an expert to do his job properly in a very limited time. It's just not going to be possible. So that has to be taken into account. In arbitration, there is the time. So the fact that the report will be produced, there may be a rebuttal and a joint statement, and then oral presentations of that, very important. The experience of the expert's important, because the more work that can get done in the joint statement, the joint report stage, to agree as much as possible is useful for the parties, whether the winner or the loser ultimately. The facts will be out there eventually, and the quicker that experts can agree, if they are able to agree, the better for the dispute, in my view. But where there is difference of experience, some experts are reluctant to agree anything, and that stands in the way of progressing with the dispute. So the fact that we have those different processes must be taken into account. The reports, they must be modern reports, easily read, well structured, executive summaries. The body of the report must be clear, appendices containing all the detail at the back, etc. Very, very important that the reports are easy and clear to read. Once it comes to the presentation at the hearing, and there will inevitably be a hearing, it's very important that a lot of work is put into the deck of slides which summarizes. And if the expert is the claimant's representative, the opportunity, which is a great opportunity, to present both the claimant's expert's position and the respondent's expert's positions together, and therefore allow the tribunal to understand the differences, saves a lot of time and gives the claimant's expert an advantage, I would say, in the presentation. And it means that the respondent's representative doesn't have to repeat everything and only needs to speak to those differences. Much more efficient for the hearing and the time taken and the cost as well. Okay, independence and credibility are key factors in all evidence. The more experienced and credible and professional the expert, the better the service should be. Export hot tubbing is, as Belden said, a relatively new area. It's developing. I've never been in the same hot tub twice. The procedure always set out in great detail and seldom followed. At the end of the day, it's really about letting the experts question each other about the differences between them, and with all due respect, keeping the lawyers away from that process to allow the tribunal to understand and then ask their own questions. So at that stage in the hot tub, it should only be a discussion about the differences and why, and allow the tribunal to come in and decide. So depending on really the experience of the experts, how effective they are in presenting their independent evidence to assist the tribunal or the adjudicator will depend on the result of that.
That on the point whether lawyers should be involved, Rod,
yeah.
As we've seen it before, there are times when one expert has completely, well, I won't say poor assessment, has carried out a pretty much a bad assessment and hasn't used the right facts, has completely gone off his own tangent. And at times that makes it very difficult for the opposing expert to start cross-examining him. Yeah. So I think there are times when cross-examination is required, and there are times when it should be just left to the experts. If it's purely technical and it's just two sides of the same coin, then fair enough. But sometimes an expert brings in another coin which is not even in the case, and then the lawyer should be allowed to tear him down, rather than the opposing expert do that.
I think that's a very valid point. And yes, I mean, I should have caveated what I said, that assuming that the experts have got equal standing and quality of evidence, and there are no red herrings which need to be dealt with by the lawyers, then yeah, that's I'd absolutely agree. It would be on occasion necessary for the lawyers to be involved in that process.
Sure.
Thank you very much. Okay, next one is strategies for adjudicator, and then Belden will end with strategies for arbitrator. So adjudicators not necessarily as experienced as arbitrators, and simple understanding the burden of proof of EOT, LAD, and lost expense would be an issue. Understanding the standard of proof required for EOT, which may be fact and law, LAD, which is principally law, and lost expense, which is also fact and law. Each party, notice requirements, causation, factual materials, criticality, all these have to be understood by the adjudicator. Use of evidence not provided during the contract to assess entitlement during the contract, mentioned before by Belden. Are you overstepping the mark? I know of one adjudicator who told me he unfortunately went on his folly of his own because he considered he had experience at assessing EOT, and that was found to be wrong. Easier way around difficult determinations. Are you just going to reject it because of a notice requirement? Perhaps would that be the right thing to do? Is that actually giving a service to the determination? So shouldn't strain to use this approach too often. If EOT causes of proof and analysis difficult to understand, request for oral presentations. If you really don't understand as an adjudicator, it may be worth asking for simple clarification. Don't be shy to do that if you really don't understand, because you do have to give that decision at the end of the day. Use burden and standard to allow or dismiss entire EOT. Is that really something you need to do or should be doing? And the apportionment and reduced assessment require intellectual appreciation and determinations. If you decide to go on the approach of apportioning and reducing the assessments, it may be beyond some adjudicators' capability to actually venture there at all.
Okay,
Belden.
so I'm going to speak on strategies as an arbitrator. The first point for me is arbitrators are generally expected to be an expert in the area of disputes themselves. I know lawyers are very often arbitrators, but an experienced lawyer in construction practice and engineering practice is one that should be able to understand things and be able to comprehend difficult concepts, because he should have been exposed to it as counsel. Now, so if the arbitrator is expected to have some expertise, then hot tubbing of the experts, the arbitrator really has to show his ability. And for that, he really needs to be able to understand the standard of proof and quality of proof. Now, very often you find arbitrators that do not understand it are the ones that don't go into hot tubbing, and they stay silent. They just let the parties do whatever it is. And then in the end of the day, do they really understand it or not? That's become the big question. But whenever hot tubbing is done, the general feeling is that everybody walks away having some depth of knowledge. And for that, the arbitrator has to take charge and be proactive in how he approaches the hot tubbing, because therefore he has to have some basic knowledge to be able to prod and to be able to ask the right questions. So there is some element here in arbitration of an inquisitorial approach during hot tubbing. Constructive assessment of merits rather than one using merely credibility is expected from the arbitrator, although credibility can play a role. And very often in arbitrations, apportionments occur, reduce assessments. Somebody claims EOT for 100 days, you only allow 50 days. That requires an intellectual appreciation, because you need to explain how you ended up with a reduced sum, or how you ended up with a reduced number of days. Avoid ships passing in the night. Now, this is an issue that I think a lot of arbitrators face huge problems in EOT. One expert will use one method of analysis, and the other expert will use another method of analysis, and they'll come up with completely different answers. And then the whole fight is about which method of analysis is the correct method. And somehow or another, rather than getting into the merit, the fight goes into which methodology should have been used. So to avoid ships passing in the night, a proactive approach to forcing experts to come to some view. Now, you cannot force experts very often to use the same method of analysis, but you can definitely force experts to come to a standing on how much data there is and what type of approach. So at least you take it away from those theoretical approaches and go back into some observational approach can, but it has to be tested according to the actual data. So once a proactive arbitrator starts to show his hands, you see experts starting to get concerned about using purely theoretical approaches in the analysis, is when they sense that an arbitrator knows nothing about assessing AOT, is when you will find sometimes, unfortunately, shenanigans about using methods that are not acceptable, should not be used, but then get away with it. So proactive approach to procuring agreement between experts, the joint statement, if the arbitrator also steps in at some point of time and takes some approach and charge on it, he can sometimes get a better product that reduces the amount of dispute between the experts. And then experts need to beware of good and experienced and knowledgeable arbitrators, because you can find arbitrators that actually understand things, and the experts are sometimes very badly embarrassed by the arbitrator themselves. So overall, as an arbitrator, your strategy in time-related claims is one that you're expected to understand, because you are being appointed to determine these things. Thank you.
Thank you, Belden. Well, that comes to the end of our presentation, ladies and gentlemen. I apologize for going over slightly, but we did pack rather a lot of information into those slides. I'm just going to check the chat box to see if we've got any questions. Let me see. I don't know if I'm operating this. No, I don't see any questions in the chat box, unless I'm getting it completely wrong. Have we scared everybody to death with how to deal with time-related disputes?
I think there are some questions. One asked about whether we share our slides with the participants. So that's fine. I mean, I think we can share our slides. There's no problem with that. One of the questions, is it possible to run a waiver estoppel argument in relation to a condition precedent clause if a party chooses to pursue a common law route? As I mentioned just now, and this is a legal question, Rod, as I mentioned just now, common law route is not available if the contract covers that particular claim. Then you are limited to your contractual right to the claim. Common law is only there where the contract doesn't provide for particular claims, and the contract allows you to still use common law. So condition precedent, where you're making a contractual claim, you can't just run to common law and avoid that. because
everybody would.
Yeah. No, essentially what happened is that, say a same claim for time, or a claim for money, loss and expense, if it's excluded by the contract because of your failure to issue a notice, you are now trying to avoid exclusion clauses by going to common law. The exclusion clauses will apply to limit your common law rights. So that's the position. That seems to be the only question that was asked, sadly. Maybe we've
still got 31 people in attendance, so they didn't all run away. But if anybody's got any questions, I guess we've got time for one or two. Sharifa, are you there?
Hi, everyone. If you have any questions, feel free to unmute and turn on your video and engage with the speakers directly. Otherwise, I think at this stage, we're good to close up the session for this evening.
So the question that someone asked, whether we'll share our slides, will I can send it to them, or
I'll send it first.
Okay.
You haven't got it yet, right? I haven't shared that with you, so we'll send it to you and you'll send them on. I'll do that straight after this.
Okay. All right. Thank you so much to Mr. Belden and Mr. Rodney for joining us this evening. BicTok is very happy to have a very insightful and in-depth session. I hope that the parties benefit from this session today. Some of our sessions are usually quite rushed because we have a lot of panelists. So it's nice to have one session where it's you get to go into detail and go through one by one instead of rushing because of the time constraints. So thank you so much to the speakers and to the participants today. We will upload a recording of the session on our website. So please keep an eye out for our upcoming talk, and we'll see you next time. Thank you.
Thank you.
Thank you very much.
Thank you very much.